Hello, everyone. Good evening. Welcome to this webinar today in a new formula, an hybrid event, both physical here in Trento University and on Zoom platform. Let's wait a couple of minutes more before start in order to allow all virtual participants to attend the virtual room. I see that the number of people attending is increasing, so let's wait for a couple of minutes more. Okay, I see that the number of participants have been now stabilized. So let's start. Good evening, everyone. I'm Michele Carpagnano. I'm the scientific director of the Osservatorio Golden Power. I'm very pleased to have here in Trento, in Vienna, our guest, Johannes Barbist, partner of the Grösswang and the University of Innsbruck. Hello, Johannes. Thanks for being here. And also we have Regina Kroll from the firm Binder Grösswang in a remote connection from Vienna. Hello. So we have to address a very important topic this afternoon. This is the first comparative event that we have in our university. So the object of this webinar is to make a comparison between the law and practice and the enforcement and the trends of FDI screening in Austria and in Italy. This is why we have the two distinguished experts from Austria that will discuss with us what are the new trends and what is the structure of the legal rules and the legal order in the application of the foreign direct investment screening. So let's start. We have an hour and a half, more or less, ahead of us. Please feel free, and I'm referring to participants who are joining through Zoom, to lodge your questions, to write your question through the platform, and we will take the questions immediately after each of the three speeches. We have organized our presentation today among these three lines of discussion. So I will now give the floor to Regina for a brief and comprehensive description of the key features and trends of FDI screening in Austria. Then it will be my turn, focusing on the practice and the law in Italy, and then Johannes will give us some comparative thoughts and some inputs for a further discussion. So Regina, the floor is for you. So please go ahead with your speech. Thank you.
Thank you, Michele. May I ask you to just get over to the next transparency? Yeah, I was starting off with a picture from the Disney world. Actually, in Austria, FDI used to be also a kind of sleeping beauty, since a very basic regime was introduced in 2011, and over a period of 8 years, there were a total of 25 FDI proceedings. So that is roughly 3 proceedings per year. In 2020, in July 2020, a new FDI regime was introduced in Austria, and with this new regime, the picture looks a little bit different, as we can see on the next slide. Yes, thank you. these numbers are from the first, or a mixture of the first annual report from our authority, which is the Austrian Federal Ministry for Labor and Economy. And they had to review a total of 70 cases, so completed. Thereof 90 certificates of non-jurisdictions, which essentially means that the transactions were not covered by the Austrian regime. So a formal decision by the Austrian authority that the transaction is not covered by the regime. And 61 full applications for FDI clearance, and thereof 58 were approved without any commitments, and 3 were approved with commitments. Commitments, to be clear, are as per the wording of the law imposed by the authority. So the authority can technically impose unilaterally commitments in the context of a transaction. We had 0 prohibitions until September 2021. We do not know whether in the meantime there have been any prohibitions, and we had 0 approvals by operation of law. Theoretically, if our federal authority does not issue a formal decision within the prescribed timelines of the law, the transaction is deemed to be approved. The top investors in Austria are, that was a little bit, yeah, thank you, Michele, are from the US and the UK, and the top sectors targeted in Austria are the health sector, data processing and storage, which is a very wide sector, as you can imagine these days, and information technology, and then finance. As to what a notifiable transaction is, we look at, nope, that was okay. Next one, please. Yes. In order to trigger a filing, we need a foreign investor. So the Austrian regime does not cover EU investors, EEA investors, or Swiss investors, either individuals or entities. And we need an acquisition of an Austrian business or material assets of an Austrian business, or sufficient voting rights or a controlling influence over an Austrian business. And the Austrian target needs to be active in at least one sensitive sector or particularly sensitive sector. And the authorization may not be contrary to obligations under union or public international law. We have one exception, namely for micro enterprises. If the Austrian target has fewer than 10 employees and a turnover or balance sheet total of below 2 million euros, the regime does not apply. So there is no notification of a transaction necessary if the transaction concerns the acquisition of such a target. The competent authority, as already mentioned, is the Federal Minister for Labor and Economy. And at the very end, you can see the timeline of Austrian proceedings. In Austria, the EU cooperation is a mandatory step. So every transaction that we notify to the ministry with a formal application is submitted to the EU cooperation mechanism. And the mechanism takes 35 days on average, and may take up to 60 days if another member states or the EU Commission have questions. And only when this step is finished, the national proceedings start. Phase 1. Phase 1 is 1 month and cannot be extended. And if the authority deems it necessary to ask further questions or sees concerns as to security or public order in Austria, they might initiate phase 2 proceedings, which take up to 2 months. And only in phase 2 proceedings, the authority can impose commitments. Okay. Yes, on this slide, you can see the sectors which are considered sensitive under the Austrian Investment Control Act. As you can see, it's a very wide range of different sectors. The first part, the particularly sensitive sectors, that's an exhaustive list. And this is triggered if 10% or 25% or 50% of the voting shares of an Austrian target are acquired. So this is the 10% threshold sectors, the most important, most critical ones. The other part is the normal, quote unquote, critical sectors, and that is a non-exhaustive list. So theoretically, also sectors that are not explicitly listed, but that could be considered critical would also have to be notified if the Austrian target is active in such a sector. And as you can see, the categories are very, very broad. So energy, information technology, and then in particular, data processing and storage. As you can imagine, a lot of companies store data or process data, and also access to sensitive information, including personal data or the ability to control such information. So all these items are as such very broad and are currently also interpreted very broadly, not I think because our authority wishes to do so, but because the law is drafted in such a manner, and at the moment they see the necessity to find out what it is exactly that we are looking for if we want to assess whether or not a transaction poses a potential threat to security or public order in Austria. Okay. Yes, the next timeline is essentially one that is most interesting if you work on M&A transactions. M&A lawyers used to only look at merger control, so that was often necessary, but merger control is a lot more foreseeable also in terms of timing. In Austria, most transactions go through, or the vast majority of transaction goes through in phase 1. Which is very short if you compare it to the FDI timeline, where we have the phase 0, which is in any case 35 days plus 1 month. And then merger control phase 2 is obviously not happening very often. So while you're quickly through with merger control, FDI can take 2.5 to 3 months if you get a phase 1 clearance, and may take up to 5.5 months if a transaction goes into phase 2 proceedings. So it prolongs the time between signing and closing considerably. Yeah, 27 months into the new Austrian FDI regime, what we hear most frequently as regulatory lawyers is in particular from foreign investors and their counsel, is it's not possible that we are covered by the regime. The Austrian target does not really do anything that could potentially be relevant in the context of security or public order in Austria. You know, it's not active in a sensitive sector, or also frequently a problem to be encountered is group internal restructuring. So the Austrian FDI regime does not contain an explicit exception for internal restructurings, and therefore these group internal restructurings are caught even if the UBO stays exactly the same. If something shifts on an intermediary level, you might have to notify the transaction to the authority. Next question is, why are we not applying for an Unbedenklichkeitsbescheinigung, so a decree or certificate of non-jurisdiction? That's because Germany has quite a similar concept. And in Germany, Unbedenklichkeitsbescheinigung means a transaction is caught by the FDI regime, but it is not a problem. It is unbedenklich. So there are no concerns in regard to security or public order. Whereas in Austria, that means the transaction is not at all covered by the regime because we don't have a foreign investor, or because the target is not active in a sensitive sector, or because the investment as such cannot be qualified as an investment within the meaning of the Austrian FDI regime. However, as you can also see from the numbers, it is hardly ever the case, because of the very wide scope of the Austrian regime, that you're not covered by the regime. how long will it still take, and what can we do to accelerate the process? Obviously, M&A lawyers are notoriously impatient, so they want to know whether there is anything they can potentially do to speed up the process. Is there any information that we can give the authority to provide comfort to get a decision? However, that's also a difficult one, since the Austrian FDI authority is the manager of the FDI proceedings, but a lot of other stakeholders are involved. There are other ministries who are part of this process. There are even Austrian provinces who are involved in the process, and the ministry, the FDI authority as such, needs to wait for their input, and that alone can drag out proceedings for quite a while. So there is very little you can do to speed up the process other than respond quickly and comprehensively to RFIs that the FDI authority might have. So what we experience is that a lot of M&A transactions are covered, also transactions where foreign counsels would think, we would never fall under the regime. Our authority is quite active. They also pick up cases from the EU cooperation mechanism, meaning if in another country an investment is made and notified to the respective FDI authority, and this is submitted into the cooperation mechanism, the Austrian authority will check whether it has been notified of this transaction. And if that is not the case, then you might get a letter saying, we saw that A buys B, please tell us why you have not notified this transaction to us. Prima facie, we think this could be covered. Connected therewith is a gun jumping risk. So if a transaction falls under the Austrian FDI regime and is not notified, that would be a gun jumping. FDI proceedings cannot really be accelerated by parties to the transaction. That we have already covered. And sometimes there are last minute measures like RFI and proposed remedies. That's also something we frequently encounter, that if parties to a transaction see that we're going into phase 2, an in-depth investigation, they ask whether we can propose remedies in order to accelerate proceedings. Obviously, that is something to be cautiously approached, because we need to know what the actual concerns of the authority are before we can propose any remedies. The authority as such is cautious. So, for example, in regard to the interpretation of what is a sensitive business activity, that is interpreted very widely, but that is, as I said, also due to the way the Austrian law is drafted. Currently, there are no published guidelines to, for example, narrow down the target sectors or address other legal questions that come up quite frequently. And a number of questions are currently unresolved. So there is a lot of uncharted territory for investors still after 27 months into the new Austrian FDI regime.
Thank you, Regina. Actually, very interesting. I like the imagine of an uncharted territory that we have to explore. And one of the tasks of our observatorio, our research center, is just to help the explorer to adventure themselves safely in this very, dangerous, because of the standstill obligation, because of the veto decisions, because of the high sanctions that you also mentioned, territory. So let's move a little bit. Thank you very much for your very, very sharp and precise description of the key elements of the Austrian regime. Now, my task now is to briefly discuss and illustrate the key elements of the FDI regime in Italy. And then after my little intervention, my brief intervention, we will discuss some common features, divergence features, and trends. So what about Italy? In Italy, we have a law that recently made the 10th anniversary. So the first law on golden power was enacted on 2012. At the beginning, the law was very narrow in the scope, so only four big sectors were covered. So the national security and defense, communication, energy, and transportation. So a very little scope of the law that has been exploded in a recent time. The first important amendment took place in 2017 when the law was, the scope of the law was extended in order to include the high-tech sector. Then immediately after the pandemic, the eruption of the pandemic, we registered a new wave of expansion of the scope of law. On the background, there was, as you can remember, the tensions between US and China on 5G technology. That was obviously a very important element in the development of the new network in Europe, not only in Italy, but across the whole Europe. And for this reason, the Italian government expanded the scope of the law in 2019. Then we had the entry into force of the regulation, the EU regulation on foreign direct investment screening coordination. And so again, the Italian legislator decided to make a little bit more wide the scope of the law, and now we have the new decree exactly after 10 years of the first decree that makes some clarity, that makes some clarifications also on the procedural aspects. So we have assisted in Italy to a sort of modernization of golden power rules, of foreign direct investment screening rules from both substantive side and procedural side. So at the present day, the law is as I said, as a wide scope that could be summarized in this slide. So Article 1, the still old structure aimed to protect the defense, national security. Article 1 bis, 5G contracts and telecommunication. And then Article 2, the more broader one, I must say, it's as you mentioned, Regina, in your presentation, in Austria you have an exhaustive list. We also have an exhaustive list of sectors in Italy, but the list is so wide that you know it's exhaustive, but it leaves open big room for interpretation. And Article 2 actually allows to enter in the scope of the law also all the critical sector identified by Article 4 of Regulation 452 of 2019 of the European Union. In order to give some certainty to the business community, to the practitioners, the government intervened very recently in 2020, so 2 years ago, with 2 secondary legislation decree in order to define with a little bit more detail the scope of the law. And now, I mean, we can say that based on these decrees and based on the practice that we can read from the annual reports from the government, some kind of clarity, some kind of ex ante indications of the scope of the law and of the sectors which are deemed really sensitive under FDI, it is possible, by the way, of a certain reasonable approximation. So given the broad scope of the law, let's briefly outline the procedural aspects. All the system of foreign direct investment screening in Italy is based on a duty to communication. The duty of communication stands on the acquiring party as a general rule. This is a duty to communicate in written using specific forms that has been approved by the government, the transaction. And this is the first important procedural element. The party have the duty to communicate the transaction no later than 10 days from signing. And this is the first important procedural aspect to bear in mind. The government, once received the notification, the communication, have 45 days to say something. If they say nothing, but it is something that never happened, we have registered in every single case a prompt reaction by the government. But in any case, the law which is aimed by a liberal principle, says that if the government in principle says nothing, the transaction is deemed authorized. Okay, so silence means authorization. But again, in our experience, always the government has said something, and has said something within the 45 days. There is a standstill obligation, which is expressly stated in the Italian rules. So the parties cannot implement the transaction without getting the prior approval by the government. And so during the evaluation period, again, as I said, there is this standstill obligation. This means that any resolutions, act, or action, or even the exercise of right that has been made before the expiry of the time limitation is null and void ex lege. So it's a nullity by the law. As a new element that has been introduced in this modernization of the procedural aspects that I mentioned before, there is the possibility for the government also to request by officio a formal notification from the parties in case of misnotification. So this is something that the government has made already 2 times, but it is a consequence of an amendment of the procedural rules. Of course, the government can request for information to the parties, but not only the parties of the transactions, but also everyone who has relevant information regarding the transaction. And there are specific provisions in the law that enables a sort of cooperation between the government and the public administration in order to exchange informations. Very recently, it has been introduced also the possibility for the government to ask the support, to request the support for the financial policy in order to make inspections, in order to get some information from the ground, in order to carry out a sort of very, let's say, investigative action, investigative activities. One additional remark on the procedure: the clock, the 45 days is stopped, is paused, or better, is stopped when the communication is deemed incomplete. So if you are communicating, if you are notifying something which is deemed incomplete, the clock stops and starts again from the moment when the party submit a new full, complete notification. The clock is paused, and so it restarts from the period when it was stopped in case of any request for information, both made by the government or made by the authorities, which composes the coordination group within the presidency of the Council of Ministers, but also in case, and this is very important, the European Commission, for instance, of any other member state makes observations or comments within the EU cooperation mechanism that we already mentioned. So this is very important because 45 days, as we see, this is a first comparative element. For instance, we see in Austria 2 months to get in the phase 2 the final decision. Here in Italy, we have 45 days, but with the possibility to stop the clocks if necessary when additional informations are required. Another important element, and we already registered in Italy some cases in court, all the decisions made by the government are subject to a judicial review. This is a full review which is made by the administrative courts, both in first instance and in second instance. We have registered already some decisions, some judgments by the court, but so far they confirmed the correctness of the operation of the evaluations made by the government. Maybe if we have time, Johannes, we can come back here a little bit with some remarks of experience. penalties in case of failure of notification. This is the original, this has not been modified, and so this is the original structure that dates back on 2012. Sanctions are up to twice the value of the transaction, and in any case of an amount that is no less than 1% of the total turnover of the company who failed to notify the transaction. What about the pre-notification? There is a lot of interest in this new procedural aspect that has been introduced in Italy this summer. This is a sort of phase 0 that we have in Austria, but is a sort of procedural tool that is aimed to speed up the analysis by the government. In other words, when the parties, each party, and both the seller and the buyer, deems useful to ask to the government prior the signing of the transaction. So in a very early moment of the transaction. This is why the law mentioned projects. So object of the pre-notification are projects. It's not a document, a transaction already signed. It's just a project. So when the parties deems that it's important to have a feedback from the government in order to the fact that the transaction is subject or not to the golden power rules, they can submit a pre-notification to the government. This is a sort of simplified notification. It is made only in Italian, not in English, because again, it's just a pre-notification, so not a formal proper notification. And the government now has 30 days to say, okay, the transaction falls outside the scope of the golden power rules, so don't come back with a formal notification. Or the government can say, look, this is likely to fall within the scope, so come back when you sign the transaction and tell me the full story again related to this transaction. And in this phase, the government can also suggest some recommendation to the parties in order that they are very likely to take into account when they decide the final asset of the transaction. Or the last hypothesis could be that the government says, no, the transaction falls within the scope of the golden power rules, but we see that there is no reason to exercise the special powers. So this new tool has been deemed very useful because, as we will see in minutes, the number of the golden power notification has exploded in Italy immediately during the pandemic and immediately after the widening of the scope of the law. So in order to reduce this big amount of notifications, this procedural tool has been introduced. Our experience says that this is working very well, and a lot of companies, a lot of legal advisors are seeking a preliminary advice from the government. But obviously, we should bear in mind that if the parties go to signing, in the meanwhile, they should notify the transaction under the ordinary procedure. This is our interpretation, taking into account the systematic interpretation of the rules. Few remarks, as I said, on the enforcement trend and data. We limited our exercise in 2021 to be consistent with the data that our colleagues from Austria has exposed. As you can see, we registered 3 veto decisions, 2 under Article 1. As you can remember, Article 1 is related to defense and national security, and 1 on the other sectors. But the majority of cases have been deemed out of scope. This, again, is something that in the intention of the legislator will be solved through the pre-notification system. So these numbers very likely in the future will be reduced. And another interesting number is related to the number of cases closed with remedies, with recommendations given by the government and accepted by the parties during the analysis of the transaction under FDI rules in Italy. Of course, we can explore a little bit more the data, also having in mind the broader picture, because we are talking about now about 2021. But if we take the numbers dating back from 2014, we can say that the veto decision that has been issued by the government are 7. So interesting numbers that say that the Italian government has been very active in exercising the special powers. One final remark before giving the floor to Johannes relates to the relationship between Italy and Austria. Diving within the annual report, we found that at least in 3 cases, the economic relationship between the Republic of Austria and Republic of Italy came into relevance under Golden Power rules. In no cases the government exercised the special powers, but the transaction was notified because the companies were active in the strategic sector. But again, no problem under national security or public order or defense, but just because, as I said, the scope of the law is very broad and it caught this kind of transaction. Another important and final remark from my side regarding the relations between our 2 countries is that in 14 cases, so it's a big number of cases, the Republic of Austria expressed its intention to issue an opinion and to make comments in relation to operations that the Italian government notified to the European Commission, or made some request for additional information. And I think this is something that we can discuss later. Our 2 countries have been since the very beginning very active in this network of exchange of information among member states under the EU regulation that we already mentioned. And that's it from my side. I will give now the floor to Johannes for his comments and remarks from a comparative view. Thank you.
Yes, Michele, thank you so much for the invitation. You know, the University of Innsbruck and University of Trento are very close. We have quite some professors from Trento coming to University of Innsbruck to teach the law students there. So I'm very happy to also represent the University of Innsbruck, where I'm a guest lecturer. Well, now it's time for the difficult task. And there would be a lot of issues we could discuss. We thought it's a good mixture to give at least some examples, of course not exhaustive, but important enough to discuss, I think. What are the common features? Now, I think the most obvious, we have one single legislation. In Austria, it is called the Investitionskontrollgesetz, the Investment Control Act. And in Italy, as Michele pointed out, we have the Golden Power legislation that has, in the meantime, been amended various times, but it's still one legislation. Now, what is the nexus to our respective jurisdictions? We also found a commonality. We either need a legal entity in Italy and Austria respectively, or we need assets of such legal entity. And then the question is, would contracts be sufficient? And I think from an Austrian perspective, and I then would ask Michele to comment. Contracts per se could only be relevant under Austrian FDI screening rules if they formed a material part of an Austrian business. And so it could be that you're covered if you're only transferring contract or a contractual position to a third party, but this would need to be examined more deeply. And other than, for example, I think in UK, where they also look at financing contracts, etc. This is not mentioned at least in the Austrian regime. We always look at business or material parts of a business or a legal entity in Austria, right? Michele, any comments on the contract side, maybe?
Yeah, thank you. I mean, for me, the task is a little bit easy because I understand, I mean, the doubt under the strict legalistic approach. But in Italy, for instance, the secondary legislation that I mentioned earlier in my presentation clearly mentioned in Italian beni e rapporti in the strategic sector. So they are mentioning expressly assets and relations. And so this fact has also for us, for practitioners and academics in Italy, to say, but what are the contracts which are relevant? And we spotted, also having in mind the practice, that it's true that sometimes the strategy is not in the asset, but is in the contract. For instance, in case the contracts relates to the energy grid, the national energy grid, or the national transportation, but also local transportation grid. But also the concessions, for instance, has been very recently included in the scope of the golden power rules. So I think it's a good example, the Italian one, and the practice also to consider not only the asset ex se, but also the contract, especially the long-lasting contract, especially the sensitive contracts with special or specific purposes in the public interest, of course, and our practice of the government clearly stressed this in also taking into account the recent amendment that has been made by the Italian legislator that said clearly the concession of any kind of relevant good, but the law was drafted having in mind the concession of water, would fall within the duty of notification. So in principle, in case you are going to change the owner of the concession, you have to get the approval by the Italian government, of course, if we are talking about a non-Italian investor or a non-EU investor. What about the concession in Austria?
I'm looking at our vice head of our FDI authority, who is present here, and she is for sure very interested in this debate, and maybe already has an answer. I do not have an immediate answer. I think concessions, normally if you transfer concessions, you also transfer the assets. So for example, the operating an electricity grid or a telecommunication grid, you would transfer the assets plus, and the concession would then go with the asset transfer probably. So merely transferring concession without assets, I'm not sure how we would deal with that, but if it's an important right, I'm pretty sure that our Austrian FDI authority would look at that very closely. I'm not entirely sure how they would decide, but indeed, in particular, if linked to the assets, I think then it's evident, and otherwise it's possible. So, right. Third common feature. internal corporate actions, so corporate reorganizations, corporate restructurings within one and the same group are covered. This is not evident. I think in merger control, we of course have the group privilege. Intra-group transactions are not covered. In Austria, and we have had several filings dealing with intra-group transactions. We have always filed and received clearances in case where a new entity in the vertical chain, so direct or indirect shareholder of an Austrian target, changed, and this new shareholder was a foreign investor, so being a non-EU, non-EEA, non-Swiss entity. And then we had to go through the clearance proceedings, even if the parent company at the very top stays the same. Right. We also had in case of an asset deal, also the assets going from one group entity to another group entity. We even had a clearance with commitments, meaning that internal restructurings are not per se privileged under Austrian law, and in case of asset deals, where the assets then go out of the European Union or Austria, I think it's very fair to screen them, because once they are gone, you'll never catch them again under FDI screening instruments. So I think that's right. I have my sincere doubts that we should also cover share deals, because you still have a hook, right? And whenever you transfer shares of an Austrian target directly or indirectly to a foreign investor, you have a hook, and it needs to be notified. And just mere internal restructurings being share deals, having to go through screening is maybe a little bit excessive, but that's my personal view. There may be reasons to still ask for notification. I understand, Michele, that Italy has a simplified procedure. Maybe you can briefly describe it.
Sure, and the scope of the law again is very clear here, saying that intra-group transactions are within the scope of the law, but they are managed in a simplified way. And so the general rule is that you have to notify the intra-group transaction, exactly for avoiding that using the intra-group mechanism, the assets scale and go outside Italy or outside the European Union. So this is why the intra-group transaction is within the scope of the law, but very interesting, and maybe this could be an example for other member states. The government, as a general rule, will not exercise any power, any special power, unless there is an actual risk for, again, national security or public order in Italy. So if you are dealing with an intra-group transaction, you are pretty much sure that it will follow the simplified procedure. The government will say, okay, I will not exercise the power unless, and it is for the government to demonstrate it, there is an actual threat related to this transaction, to the national security or public order. So this is why we have a simplified procedure, which is a very fast one. And actually, in our experience, in almost all cases of intra-group transaction, the transaction has been cleared very quickly.
I just wanted to ask how it could be in case of a share deal. Let's keep it simple. For a share deal, how this could affect security and public order, because, you know, at the end of the day, the ultimate parent company stays the same. Otherwise, we wouldn't have an internal restructuring. And so why should that be different to the status quo, right? My understanding was in case you check whether a transaction poses a threat to security or public order, that you compare or that you take into account the status quo, right? And then you compare it to the counterfactual and the transaction, right? So I thought in at least in share deals that it's very difficult for me to say compared to the present situation that there is something that deteriorates. But maybe there are cases and maybe there are circumstances, and for sure in asset deals going outside the country, the jurisdiction, this is accepted, of course. But yeah, maybe I'm not too creative to see the threat, but fair enough that FDI authorities maintain their powers and have a look.
Exactly. That is the point. I mean, I think that, again, in Italy, at least, we are experiencing a very prudent and proportionate approach. So it's true that the law foresees also for shares deal, for share deal to notify. But again, the outcome has been always green light, go ahead, there is no threat. But I think the law has been designed in order to keep an eye also on that. But take into account also that, for instance, in Italy, it is relevant if you are changing the legal the legal activity of the company. I mean, if you are changing the typical activity of the company, or if you are moving the legal base of the company from a country to another country outside Europe, you should have to notify this decision. Okay, so again, a formalistic approach, but it confirms again us that what they have in mind is to control the asset, to control the technology, to control the influence on the intellectual property right, the knowledge, the know-how, etc. No?
That is interesting because that would mean also sort of outbound investment screening, right? But by means of a transfer of the legal seat, or that's very different to foreign investment control, right? In the strict sense, because we do not have an acquisition, we do not have an investment. We are just transferring assets from one country to another by one and the same entity, shareholder. There is no acquisition. There is so strictly speaking, and I don't know the EU FDI screening regulation by heart, unfortunately, but I think this is a very broad concept then, and maybe we end up there, but at least under Austrian legislation, such mere internal reorganizations of assets, as long as there is no new shareholder in the vertical chain, being a foreign investor is involved, we could not screen it because it's not a foreign investment.
Yeah, but I just want to point there because we have a lot of other topics to discuss, but it's very interesting. Yeah, but think about the situation where the foreign investor is already owning the majority of the shares of that company, no? Because we don't start from a situation where all the shares are at the hands of Italian or European Union investors or Austrian investors. And so maybe the asset is already far from the country, and this is another additional step towards that. But again, the rule is...
What I'm saying is our trigger event is an acquisition. Right? Okay. Our trigger event is acquisition of a certain percentage of voting rights, acquisition of assets, acquisition of control, but not transfer of assets outside the country. This is sort of a different methodology, right? So
exactly, this is the point. In Italy, the trigger events are twofold. The first one, the acquisition, but also any other decision made by the strategic company, because we're not talking about every company, the strategic company, which affect the disposal of the asset, which affect the capacity to exercise, let's say, a control of the assets. And so if you change the legal seat, this is relevant. No? If you move the factory from which the strategic factory, again, I mean, the factory which provides the, I don't know, a strategic contractor in Italy, you should notify it. I'm not talking because obviously I need to precise this with you, but maybe for the public, it's important to understand that one thing is to notify the transaction, to communicate the transaction. A completed pair of hands is the exercise of the special powers. No? And so here we are talking about the trigger event to get the transaction on the desk of the government. And then the government very likely will clear it without any problem.
All I'm saying here is this discussion means or may lead to a reform of the Austrian, maybe other EU member states regulations, because the US already discussed outbound investment. It's a little bit of a different concept where when you want to export technology, know-how, etc., dual use products, etc., that you have an outbound investment screening prior to allowing technology, IP rights, etc., moving away from or being licensed, etc., right, outside of the jurisdiction. But here, what you are saying here is sort of in between, where the assets stay within the legal entity, within the group, but are just moved to another country, right? So it's under Austrian rules, you could not catch it, but you might want to catch it. So our Austrian colleague representing the authority may have thoughts for a reform. Let's continue. Projects or programs of union interest are not per se within scope, which means that they are not a trigger event. So we still need acquisition of voting rights, of assets, acquisition of control, and the mere fact that the projects or programs of union interests are involved is not a trigger event under Austrian and, as I understand, Italian law. What else?
Sorry, not the trigger event, but sorry, Johannes, but something that the government takes into account when it makes the assessment. So, especially if this is a very important project, especially if this is ongoing, has not terminated. And so this is why, and maybe you will mention later, in the EU form for the collection of information, it is clearly required to specify if these kind of projects are part, no, of the target value.
Michele, you're totally right. Then we did not find an explicit power by our Italian and Austrian FDI authority to, for example, block a transaction or impose mitigating measures in case there is no problem under our local jurisdiction with this transaction, but another EU member state has concerns. European Commission gives an opinion, another member state requests our FDI authority to impose measures, right? But let's take the example of Austrian. Our Austrian FDI authority says we do not have any problem with the transaction for the Austrian security or public order, but Germany said please block it because Germany doesn't have a jurisdiction over the transaction, for example. So using another member state to gets their interests secured. And what I think in both our jurisdictions, there is no explicit legislation. What we have in Austria is a very broad understanding of what is a threat to security and public order, and indeed it is not, the wording is not limited to Austria. So technically you could maybe block it even, right? I just don't know whether this is a practical debate or whether it is too theoretical. But we are here in academia, so that's perfectly fine. I assume this was the idea of the EU screening mechanism at the end of the day. You know, if you go that far, that would be the ultima ratio, maybe. And yeah, let's see what the future brings. But at the end of the day, this could be indeed a scenario.
Yeah, we also, that's very quick in market. We also have noted in Italy, especially in some very critical veto decisions, that the government, as a reinforcing argument, said, look, this is contrary to the public interest in Italy and also in other member states, as it has been noted within the EU mechanism. But the case that you are posing, I mean, if there is no actual or potential threat in the screening country, can the screening country go out and say, no, I veto this because this is problematic for another member states? Could be a very interesting case to challenge in court, actually, because, you know, we are talking about here powers that are strictly related to the national security, the public order of the screening state, and this is very clear also in the EU regulation. But maybe in the future we will see an amendment of the regulation in Europe, sort of, you know, or there are two hypotheses, or one-stop shop like the merger control, or in case the member state does not have jurisdiction, the other one within the network can exercise on behalf of that. But again, from my mind, the actual state of legislation could be very hard, could very hardly tolerate a solution like this, at least in Italy.
I think we are aligned for once, Michele, for once. Yes. Would you mind going to the next slide? Thank you so much. Common features in the administrative practice. This is these are figures from the EU screening report. Italy and Austria are among the top 5 EU member states notifying cases to the EU cooperation mechanism. So this doesn't mean that these two jurisdictions or even the top 5 EU member states receive most of the notifications. Rather, they are just very keen to notify the cases to the network. Germany, for example, has a different strategy. They are only notifying cases to the cooperation mechanism in phase 2, and that's why the figures for Germany are lower, despite a very high number of cases being notified to the German ministry. Right. What else? We see already transactions that have been cleared with mitigation measures. You see the numbers, and in Austria, no blocking decision has been taken. Yes, at least that's my understanding. But since we do not get any published decisions, and the new report has not been out, and of course for the current year there is no report yet. This could be, but I doubt that we already blocked a transaction. What else do we have? Michele already pointed it out. We have an implementation prohibition until clearance, meaning that the transaction may not be closed until clearance has been obtained by both the Italian and the Austrian FDI authority. It also means that we cannot enforce our transaction agreement before the national courts. It's a civil law nullity sanction, and therefore M&A lawyers should be very prudent to and always involve the FDI experts to make sure that the transaction is sent to the right places. Gun jumping, we had already one gun jumping case where we were involved after several months of gun jumping. It was in the early days of our new regime. It was in a sector that probably no one would have really thought is sensitive, but as administrative practice of our FDI authority evolved, we got to know that this becomes very strict, and this was taken up by the FDI authority in ex officio, and the target was approached, and we as legal counsel to the acquirer were then mandated to solve the problem, right? And fortunately enough, we did not get any sanctions, but in future, I think gun jumping may also be more harder enforced, right? FDI authorities may pursue ex officio investigations. Yes, that's what we both see sometimes. We have active authorities, which is probably a good sign for legal counsel, right? Because they can then also say, look, this is not just written in the law, it's also enforced, and be very careful. And as we try to be compliant, we always try to do the right things and recommend filings where needed. Okay, next slide, please. Material diverging features. We still have a little time to discuss major differences, and there are indeed various differences. Let me start on the bottom of the slide. Greenfield investments are not covered in Austria, but are covered in Italy. That is interesting. What is also interesting is the definition of sensitive sectors, and whether we look at all investors, non-Italian or non-Austrian investors, or non-EU, non-EEA, non-Swiss investors. Let me start with the home jurisdiction. For me, that's Austria. We only look at non-EU, non-EEA, non-Swiss investors. So Italian investors are privileged, but only, and here comes the bad news, only if the vertical chain up to the ultimate beneficial owner remains privileged. So if you have an Italian company that is owned by a UK individual, this is a foreign investor, and therefore we need to look at the specific transaction. The mere fact that it is done via the vehicle of an Italian company does not change our assessment. And then we have these differences in the description of what is a sensitive sector. We won't go into the details, but you will remember Regina showed two lists. The first list, the very critical sectors, are exhaustive, whereas the second list is only demonstrative exemplary list. And this is very broad and is interpreted very broadly by our FDI authorities. So to our experience, and we have filed really many cases over the last 2.5 years on the sensitive sector, we never succeeded to get out of scope. We didn't even try because we just know the very broad interpretation of our administrative authority and advice in favor of filing. What we do have is also a difference in the voting rights thresholds, right? And we can't go into the details, but you can see that the Italian triggers come in already at 3% or at larger than 3%. Just for the defense, 3%, others coming in at 10%. And what you can also see under the slide for Italy is that you also have situations where even Italians or Austrian companies, individuals must notify, and that's a really the most important difference to the Austrian regime. But bearing in mind again that you need to look up the vertical chain to the ultimate beneficial owner.
It sounds a little bit strange, honestly, that also Italians are deemed foreign in Italy, no? It's a sort of paradox of the golden power rules in Italy, but I think this is a technical, it's a very teeny technical reason why. Because as you know, as I briefly described in the first part of my presentation, the Italian legislation has been widened in the scope following the pandemic, and taking the occasion of the entry to the force of regulation of the European mechanism. And so at the end of the day, for a transitory period, for an interim period, also EU investors were deemed subject to golden power rules, no? So EU and not only extra EU as in the past. But then the legislation has been amended in March and then implemented in this summer, and they stabilized this intra-EU investors duty of notification. And so in order to avoid a procedure of violation of principle of freedom of circulation of capitals and of establishment, the rules has been interpreted clearly actually by the law, involving also the Italian one. So at the end of the day, we are not discriminating against everyone who is not Italian, but so we are considering EU-wide investors, also company owned by Italian residents, when they acquire a controlling stake. So at the moment, the very important and something to be reminded difference among EU, Italian and non-EU investors is what they are acquiring. Because if they are acquiring a minority share, so 10%, for instance, outside the defense sector, so they are subject to notification. The Italian and the EU-based investors, they are subject to notification only if they acquire the majority stake, the controlling stake. So this is at the moment this very teeny and legalistic solution that has been found by the Italian legislature, which is coherent with the three very important decisions by the European Court of Justice and the decision by the European Commission that started the procedures for infringement of EU law against Italy in the previous regime of the golden share that was deemed exactly in contrast of the principle that I just mentioned. So in order to avoid, again, these tensions to the compatibility with the EU principle, the Italian legislator, as I said in March, decided to extend also to Italian investors. So I think it's important to explain this because it seems like a paradox that Italians are deemed as foreign investors in Italy.
I just lost my connection to the University Trento internet, so if you don't mind, I may use your computer. Would you mind going to the next slide? No, I just saw one bullet point I wanted to mention, the exemption for micro enterprises. I think that is in practice one of the last resorts for us to qualify a transaction not notifiable in Austria. This is indeed the definition applied by the European Commission under the SME communication. We transposed that into national legislation and specifically exempted micro enterprises. So that is indeed relevant, and the Austrian FDI authority accepts that, and it is sometimes the reason for the FDI authority terminating the ex officio proceedings, because they see from the EU cooperation mechanism that there is a nexus to Austria with an Austrian subsidiary, and then they inquire via the target why there was no notification, or please give more details. And when you then say that the target is and can document that the target is a micro enterprise, then everything is fine.
So it's sort of de minimis. No, it's sort of de minimis threshold based on the very small nature of the target.
Yes.
Good. We don't have this in Italy, and again, the relevance is made only on the asset. But let's move to the next.
Let's move to the next. Substantive test. So both jurisdictions have the substantive test of a threat to security or public order. In our discussion, we just noted that despite this same terminology, we may have a different interpretation or broader application of this concept in Italy, where it appears to me it's also used for workforce considerations, maybe also industrial policy considerations, whereas in Austria you would probably stick to the maybe narrower concept of security or public order, at least for the moment. I think there's a lot of room, there's a lot of legal uncertainty with this test, and so I don't know where we'll end up, but for the moment it's certainly not workforce that we would look at. All our remedies that we saw were on security of supply, more or less, right? And it was mainly in the life science sector where I do have some sympathy to secure supplies, of course, but we never saw it as a real tool to pursue industrial policy considerations, really. But you have a different experience.
Oh, this is I fully agree. This is the big risk that we face in Europe, not only in Italy, as you just mentioned, also in Austria, on the misinterpretation, misenforcement of this set of rules. That because as we said, we are, as I remember what Regina told in the beginning, we are in a uncharted territory. But it is important to know that this uncharted territory could never lead to an industrial policy outcome, because this is not is not why the law has been enacted. This is not and should not be how the law is enforced. It's true that also in Italy we have seen in some decisions, some remedies which relates in a certain way to the keeping the workforce in Italy or maintaining the level of occupation, etc. But I think that they should not be the core of this law. They should be not the core of the decision. And if challenged in court, a decision based only on this reasoning should be annulled. Because again, we are talking about a very relevant exercise of power and the balance between the freedom of enterprise and the exercise of this special power, which are special, has been should be very strictly respected and interpreted. No, and I must add that in Italy we have a clear provision in the law, but this is also in the regulation, that the law should be enforced applying the principle of proportionality and necessity. No? And if you remember all the discussion about the remedies in merger control, for instance, we should take advantage also on that experience. So extrema ratio, something that you already mentioned. So is the protection of workforce, if not related to the know-how, if not related to specific know-how strategic for the national security, is something that is within the scope of law.
The sanctions, we found material differences in sanctions. We in Austria have a regime of criminal sanctions, and whereas in Italy it's administrative fines, much easier to apply. To my understanding, in Austria we did not yet have criminal proceedings, but we may face them. I find it a little bit difficult to see criminal sanctions against legal representatives of the acquirer, wherever they sit. How do you want to enforce it? Isn't it much easier to enforce administrative fines against companies? So I wonder whether we will maintain this criminal sanctions regime. Somehow it reminds me of Austrian competition law, where we also had criminal sanctions at the beginning and then moved to administrative fines. Yeah, I have my doubts whether this is really practical and enforceable easily, etc. Procedure-wise, I gave you a screenshot from the most recently published OECD report, very interesting document, where you see the timelines of the Austrian and the Italian proceedings. The first on the top, you always see the national proceedings, the domestic review proceedings, and the second, the lower line is the sort of cooperation mechanism, right? And what you see here from at first sight is that, as Regina pointed out, in Austria, the EU cooperation mechanism is before the actual national screening proceedings, which I find has two sides. That the positive side is that you can take into account all the comments, opinion of the European Commission received in this early phase, and then you start from zero again on day 36 or at the latest on day 61. The bad side with this long phase zero is that you just don't start the national proceedings. This is a very unfair statement, I have to say, because the FDI authority more and more already engages with parties, also in this early phase, maybe already asks questions, but they may also come from the EU cooperation mechanism. So we do not really have any transparency there. But if I had a wish to our Austrian legislator from an M&A, so to say, timeline perspective, I would rather go for the Italian regime, and maybe then allow for longer phase 1 proceedings or stop the clock mechanisms, but just having a very long phase 0 is somehow difficult to accept, to explain to legal counsel and parties. So I don't know. I have my problems.
No, the funny thing is that the European regulation, which has been enacted in order to coordinate the member states, doesn't foresee a uniform rules on procedures, because this is exactly the point that you raise. Imagine what happens if you have to make a multi-jurisdictional notification, no? Where you started, for instance, in Italy, because in Italy we start immediately with the formal notification and the activation of the EU-wide cooperation mechanism. But then the timing is completely uncoordinated, because maybe the national phase in Austria should wait the closure of the EU procedure, or maybe the Austrian authority is informed not directly by the party, but through, as you said, but through the European cooperation mechanism. So, in our experience, the Italian procedure with the recent pre-notification system, I think it's a good balance, especially because in the normal times, in 45 days, business get the final decision. In some cases, of course, the clock can be paused, but at the end of the day, the timing is quite manageable. And also in our experience, and we worked also with Johannes and Regina in some cases together, it's true, the Italian government is one of the first one reacting, and then you have to wait all the other jurisdiction. There are some jurisdiction, don't forget this, in Europe that takes 6 months, up to 6 months to have the final decision. So I don't know if there is a magic procedure here, but it's something that should be addressed at the European level.
Yes. Now, last slide. Institutional setup. I think we just briefly mentioned it. In Austria, we have the investment control unit, staffed with, I would guess, 5 to 6 lawyers. One I think is an economist, and this is very, very small resources, I think. Also, they have to deal with a massive workload. Just imagine they have to screen all the information coming from the EU cooperation mechanism. There are a lot of filings in Austria that need to be done. I think we have several cases in front of the FDI authority preparing 2, 3 just at the moment for filing. So indeed, high workload, little resources, and I think that's a little bit of a problem also for the internal organization by the Austrian authority. Yes. I just look at our list. Yes, I think maybe that the most interesting is the pre-filing mechanism. Maybe if I may choose the last topic to discuss. This is interesting. We have a totally different setup. I think our Austrian authority is hesitant to discuss projects and to discuss just on an to give a formal decision on the basis of a short notification, because my understanding is that the pre-filing is rather short, not fulfilling all requirements of a proper formal notification. Whereas in Austria, yeah, you would have to comply with more or less all formal requirements of a notification, even if you just want to request a certificate of non-jurisdiction. So the benchmark or the hurdle is very high to go down this line, right? And you don't have an easy, quick mechanism where you can just discuss with the authority, get it done, get it out of the way. And at the same time, I think there is not so much practical need for it, because we have such a wide interpretation of the sectors, right? And we have only a very small percentage of cases that fall outside scope. That the relevance of the pre-filing is not, that much of an issue as compared to Italy, I understand, where you have more than 50% of the cases being done in the pre-filing phase, right? Yeah. I don't know, Michele, if you want to add, otherwise I would stop for the moment.
Yeah, I mean, before taking some question from, or in the meantime, someone from the audience, maybe we can write some questions, and also to open the floor to Regina, or if you wish, if she wants to make some other comments from her part. A few words on pre-notification. This is something very new in Italy. As I said, we have just a couple of months of experience. The aim of the legislator is to not to discuss with the parties. We don't have a pre-notification system like the one in the merger control. No, it's simply when the parties have reached, or even one party has reached the idea to fulfill a project regarding a potential target in Italy or potential investment in Italy, also to an intra-group transaction, they can fill a form. There is no form, actually. There is a sort of what you have, the information you have, you can give to the government, and then they give you a feedback. But again, the feedback is very scant. It's a very brief decision saying, look, on the basis of what you represented to me at the date, the transaction is out of scope. That's it. So obviously, if the parties misrepresent the facts or give inaccurate information, or they completely change the project in a later stage, obviously this should be subject to a new assessment and even a new notification or pre-notification. There is a little bit strategically, it's not still clear if it is useful to pursue a pre-notification and in principle wait up to 30 days, or to go with an ordinary notification and get the final, formal and full green light or decision to make a further inquiry from the government. Again, it's something very new, but what is important to clarify, at least for the purposes of this webinar, is that there is no space for engagement in discussion with the government as the pre-notification has been conceived in Italy. We are a little bit out of time, but we are very keen to answer to any questions from the audience. I remember you can write your question in the chat, and we are very happy to answer. There is a question from the audience here in Trento. Maybe you can come here. Venga di qua, perché così la vediamo.
Hello, everyone. My questions, first of all, thank you for this comprehensive presentation. My question is about the two different systems. So on the one hand, we have like an Austrian system. First, it has more filtering in terms of who is considered as an investor. So it has a more precise definition of this. And concerning the scope and the thresholds, it is a bit difficult to trigger the mechanism unless if you are not damaging security or public order. But on the Italian case, we have like the definition of the who is foreign investor might change according to the one sector to another sector, and the scope is a legal sectoral scope is wide and the threshold is low. So it is possible, it is likely possible that the system, the FDI screening system will be triggered so easily. So since like on the one hand is more kind of liberal compared to Italy, this system, what might be the factors apart from the like the perception of the security and then something like those kind of abstract terms, what might be the factor that is driving the countries to define their system so different to one another? And a quick question to Austrian system, because the Italian system we can find a similar system when we look at the France, because they're also so strict and their definition is also changed up to the one sector to another sector. But I think the Austrian example is because of being a liberal and providing certain predictability to the investor is not common practice in Europe, if I'm not wrong. So what are the other systems in Europe that are similar to Austria? Okay, thank you so much.
Thank you very much. Thank you for your question. Johannes, or maybe Regina wants also.
Regina, yes, do you want to start?
Yes, of course. I'm happy to start. If I grasp the first question correctly, I would start out with saying that I would say that the Austrian system is not difficult to trigger. It's very easy to come within the ambit of the Austrian system, but whether or not the transaction is then considered to be a threat to security of supply, so the material assessment, that's something that is a little more thorough and obviously more difficult to trigger. When it comes to what is the factor that drives countries to make their systems so different from each other, I would say the EU FDI screening regulation just proposed a minimum standard, and a lot of the major factors that are subject to FDI screening come within sectors that are at the core interest of sovereign states, so to speak. So I would think that even though we are in a European Union, the member states as such, they want to keep a lot of these competencies to themselves. So they want to decide what is a strategically important asset, what are strategic infrastructures in my particular case.
You want to add something?
Yes, maybe just adding that you remember in Austria we had a regime, we've had the old regime since 2011, and we had very many gaps here, and so I wonder whether the Austrian legislator didn't say, look, of course we want to introduce a good screening regime, but we do not want to go that far for the moment. So from 5 to 10, maybe just to 7 or 8 for the moment. Also, it is very broad in the sectors, but limited to really non-EU, non-EA, non-Swiss investors. This maybe is the first phase. Maybe in a reform may lead to the Italian, French, German system, where in certain sectors we also look at EU investors, and I think that is even probable, maybe not even stupid. and maybe the right way, just looking from a purely member state perspective. I think what if you have a more broader look and you see the citizenship of certain member states being granted to foreign persons, I think this is a very interesting debate, right? Because at the end of the day, this means that they are privileged in various legal areas of law, including FDI screening, which is certainly not what we anticipated, right? I just take the example of Russia, which is of course prominent these days. My understanding is that in one or two of the member states in the southern part of Europe, it's rather easy for them to get EU citizenship, or was in the past. So by the mere fact that they get a favorable treatment there, they are considered EU investors, and we have no hook left. So this would point towards Italian, French, German system, but I just don't know. I think we should tackle this problem from scratch and avoid these preferential citizenship models, of course. But yeah.
Okay, no, thank you. Actually, no, thank you for your question. It's I think it's very well pointed to the core of this legislation. It's true that in Italy, some sector, but just defense and national security, have a lower threshold. But this is for obvious reason. I mean, we are talking about, by definition, very, very sensitive assets. And I must say that since the very beginning of the Golden Power rules, and so I'm dating back 2014, the first decision of veto was related to an attempt by a French company to buy an Italian operator active in the production of radio devices in use of the military service. And it was not extra EU, it was a French company. So purely within the EU, purely in a completely different world, let's say, no? And so I think that worked because defense and national security, Article 1 of the law, maybe require a more strict approach. If we go further, and so we are talking about the sector of the regulation with a very broad definition, with a not strict catalog of activities and assets, etc., the risk of expanding this legislation also to European investors, I think it's not a good sign. I think it's something that runs counter to the principle of the European Union market, of the common market, and are exactly the reasons why, if you go back in the history of the Golden Power, because Golden Power now is very on fashion, it's very fashionable, but Golden Power rules have been already under the scrutiny of the Court of Justice and the European Commission under the compatibility of the principle of freedom of establishment, of freedom of circulation of goods and capitals. No, so don't forget this. Don't forget this story. Can you? I think the connection. Regina, can you hear us? Ah, yes. Okay, because one device now is out of service, but we are still here. So just to say that let's be cautious. Let's be cautious on foreign direct investment screening, because, as I said, the risk of the misuse, of a misenforcement, especially within the European Union, is very high. And so I don't know if we answer to your question, but okay. Yes, we are a little bit out of time, but we have still a few minutes for a final remark.
Just like a quick reflection. My question I mean, for your the response, yeah, it is under the European Court of Justice scrutiny. It has been like there are also members that has been included in their legislation, like Denmark, Germany, like they have this kind of certain practice for many years. It's not something new, but again, it is like in Italian case, or like let's say it's the general trend in Europe that is like a general screening mechanism. So, and the member states allowed to, I mean, not, let's say in this way, member states shouldn't restrict the investment within the Europe because of the internal market, but yes, this is the rule, and exception is the security, but it seems that it is going to change. I mean, I don't know whether I am clear or not, because now many member states are screening also on a kind of economic base, but it is of course the reference points is security, but since they are not allowed to screen each other on the commercial basis, but of course there's also misuse, not only from the foreign investor side, but also the competition between the member states.
This is something, few minutes more, Johannes, this is something that, of course, has been already addressed by the European regulation, which clearly says, look, member states, you cannot use the regulation to make a sort of, trade battle among among yourself. You cannot discriminate based on nationality of the investors. And again, I think it's very important to stress this. One thing is the screening. So something which is within the net of the government. The other thing is the exercise of special powers. Because if we go, apart of the example of France, but in Italy, let's take the 6 cases of veto, one France defense, the other one are related to Chinese investors and Russian investors after the Ukrainian attack. No, so obviously there is some geopolitical background there, but my impression is that despite this very high number of cases within the net, the mechanism is working very well. And the judges are there, and we stress the judicial review, exactly to ensure that the law is applied and enforced in a proportionate and necessary way. No? So let's see, it's something in the early stage, but the concepts are very important and very grounded in, I don't want to be romantic, but they are very, very, very based on the pillars of the European Union and the European market, I must say. What do you think, Johannes? And then we close.
No, Michele, I fully agree. All I'm saying from an Austrian law perspective, we even have the compliance with EU primary law within our FDI screening legislation as a so if you violate EU law by requesting a mandatory notification, you need not file, right? So that's, it has never been applied in practice, but I do see some ground for enforcement of EU law, even not at the very end blocking transactions, but also whether you indeed have a right of a member state to screen each and every transaction on the widest possible interpretation of what is a sensitive sector. So we need to be cautious. I think that this remains within the ambit of the exemption to the freedoms of the European Union, etc. But I do agree that for the Italian system, I think it works. The Austrian system appears to me very broad on this, too broad on the sensitive sectors. Whether this is already a violation, requesting notifications without any blocking decisions, I leave it for the professors.
No, it's a good. Thank you, because I mean, very interesting, interesting discussion, and this confirms how important it is to have hybrid event, not only virtual, but also physical, to be in presence and to share view. So thank you very much to Johannes for his very useful and clear and competent comments on all this. Thank you also to Regina for her brilliant explanation and illustration of Austrian regime. Thank you, Regina. Hope to see you here in Trento next time in person.
Happy to join in person next time.
Sure. And also thanks to the attendees, because not only the physical one, but also the virtual one, I see a very good number, despite this is not most typical of Trento nor Austria to be late, half an hour late. We never close late webinar, but this is a very nice exception this time. And just to thank you again, everybody, and to remember that this is not just the first comparative webinar on FDI. Next appointment will be end of January, with a comparison between Italy and the Czech Republic. Again, hope to see you again very soon, both in presence and virtually. Thank you very much. We can close the webinar here. Grazie.
Thank you.
Thank you.